Welcome, everybody. We've been talking about a little bit in the chat, welcoming folks, and people reminding me that it's Cinco de Mayo. We used to have a celebration of that every year in my town, but with the COVID-19, we didn't have it. I guess we didn't have it last year either because volunteerism faded a little bit, but it will start up again next year, I'm sure. Anyway, other celebrations that folks are trying to do without being able to gather in groups. Or maybe I should say, what would you celebrate if you could get together in a group? And I'm putting up the objectives while we wait here. Yeah, there's a number of things that we're missing in my community, of course. We're missing our town celebration. I hope we won't miss the county fair, but we may miss that too. And a number of other things. This is interesting because this is one I never really thought about. Non-lawyers liable for legal malpractice. I didn't really see that. I thought perhaps they could be sued civilly and criminally for practice without a license. But I didn't really think about it in terms of attorney negligence. I don't think of it as being non-attorney negligence. That seems odd. The case that was given to us was appealed by one of the attorneys involved, one of the cases in terms of legal malpractice by a non-attorney. But that was the attorney, and all it really did, the appeal did, was just limit the damage for that particular attorney, perhaps for both attorneys. There were two attorneys, a paralegal, and a manager of a business who was neither a paralegal nor an attorney. And the manager who owned the company was handling personal injury cases sort of as a non-legally qualified person, and then hired a couple of lawyers and later on a paralegal to assist. So apparently a marketing person decided to do it. I'm not quite sure what the person's background was, but it was interesting. And then, of course, if you're thorough, you would jeopardize it. We'll take a look at it in a bit here. It's one of the cases referenced in the lesson content. And then, of course, consequences of unethical conduct by a paralegal. We don't do too much with that other than that case or those cases. Yeah, it's and then this one is also interesting because state law does not really deal with this, or unless your state does. I cannot state that categorically, but I have not seen state law deal with this. But there will be new laws coming out, I would suspect, that deal with the issue. Okay. Questions so far, just in terms of the objectives we're going to focus on? It's not very often that a paralegal actually reports unethical conduct to the professional board against the paralegal's own employer. Have you heard of that, anybody? It may happen. I just haven't seen it. And I have not done a comprehensive set of research on it. So again, it's not about whether I'm right or wrong, whether my guess is right or wrong. It's about what you find out from research. We don't have to do that right now, but put it on the back burner, put it on your list of things to do in the future, perhaps not as part of this course, but something to look at. We have the NFPA, which the lesson notes rely on more. On informing, would say on reporting. Yeah, that's interesting. But the NFPA kind of takes a soft approach. Do you have any speculation on why the NFPA takes a kind of a soft judgment call approach on that issue? Speculation? I put something in the chat, by the way. I found out, though, that the chat does not show up with when you watch on YouTube. So if something escaped you when you're listening by recording, just let me know. I will fill you in. So reporting on one's own employer, that does that get anybody kind of revved up about this? Interested? Excited? Worried? I'm looking for some kind of a reaction. Okay. Try to come up with one or two questions. One of them could be about that. Yeah. But remember that the NFPA is giving you wiggle room where it's not a serious, terrible thing. Let's say that something was done wrong, but no client was harmed. There's the NFPA is not being really, really tough on the paralegal and putting you in a box. And of course, they don't have the force of law. It's not like if you would disobey the NFPA that you're going to be drummed out of the service and no longer be a paralegal necessarily. But I think you should pay attention to that secondary source when it's the only source, okay? So pay attention to it, see how they think about it, and then think for yourself. No. Cindy, lawyers don't. Of course, I'm in one particular small town that I've practiced in. So if you ask about me more than 2 counties away, they may not even know who I am. Okay, so aside from Todd County and then the surrounding counties, in other words, I'm not a famous lawyer. I'm more famous as a paralegal instructor. Of course, that's what I've been doing mostly the last 12 years. So, but I don't recall in my area, 7th District of Minnesota, which encompasses quite a few counties, but in my area, I've never heard of anyone trying to discuss employees and potential employees. Lawyers, remember, lawyers are intensely hyper-competitive. So the idea that they're going to get together with other lawyers and talk about who to hire, who not to hire, seems kind of remote to me. I mean, um, best buddies, I suppose there are some best buddies, for instance, but sometimes the best buddies are 100 miles away because of at least in my state. So one of the first lawyer that I worked for before I became, well, the only lawyer I worked for, you might say. I suppose technically I worked for two lawyers, but one of them was the boss. Okay, so I worked for one person, and his best buddy was 120 miles away, and he would refer cases to that person. But I don't know that he really would have compared notes with other law firm owners. Um, he would have more compared notes with his friend that was 100 some miles away. So, but at least in my area, no. Anyway, any question about the focus attention questions and loci? Remember the lost keys story? How many, just put a Y if you remember the lost keys story from me. Okay, good, okay. Is anybody, well, I won't ask you. I don't want you to respond, but if you haven't tried it, but don't lose somebody's keys. Lose something the size of keys that is replaceable. Because if it's a truly messy room and you put a token, like a small cheap medallion somewhere and you try to find it, you may not find it, and you'll be glad that it wasn't somebody's important keys. But I suspect, though, you are resourceful enough, you probably would end up finding it. But if you had somebody hide it that forgets where they put it, if it's a truly cluttered room, it may not be findable, or it may, something put under a seat cushion could fall through a crack and you'd have to take the cushion or have to take the sofa apart if there's a break in the fabric. So don't do that on purpose, but I mean, try to find something in a messy room and see if you agree with me, okay? But one of these cases was reversed, but only partially, and that was the Tegman case. So take a look at these two cases. They're referenced right in the lessons. And notice when I looked for them, I didn't need case names. I did use spaces. Do you see the spaces that I used? But I didn't need to use the correct capital letters. So I didn't have to do this correctly. I didn't have to type the period in. Do you see what I mean? To find it? If you can write down just this part of it and type it partially correctly, it'll show up in Lexis. Then what can you do? Then you can shepherdize it and find out if it was reversed. And it was partially reversed, which helped one of the defendants, okay? But it wasn't reversed in terms of its general idea, is that a paralegal can be sued, a non-lawyer can be sued. So if somebody not a law firm hires you to do private cases, they're not a law firm, and they're doing private cases for other people, not for themselves, not as like a company with an in-house legal department. If somebody wants to practice law without a license, don't help. That would be the lesson for the day. 2 lawyers and 1 paralegal helped and regretted the day, put it that way. Reflection questions from this NFPA ethics opinion. What is your duty to report an issue of competence? These are thinking exercises that are not strictly speaking required. Questions about why these are in the lessons? Questions, problems? There have been impaired lawyers in my area that were impaired due to treatment. I'm not giving away any client information since those lawyers were never my clients, but in Minnesota, there is something called Lawyers Concern for Lawyers that would help with impaired attorney who is either deeply depressed or perhaps alcoholic, and Lawyers Concern for Lawyers would help the person. But you would, if it's a law firm of more than one lawyer, you would probably try to get the other lawyer to assist you and so on. Otherwise, you could you could call Lawyers Concern for Lawyers and have that person have one of their representatives call the lawyer. Okay? Does that answer your question, Cindy, or am I off your topic? Okay. LCL. I'm not promising that there's one in every state. Yeah, in Minnesota, it's run by somebody who used to do employment counseling and so on. So very capable individual who's the director. And then, of course, there's other people involved. There's attorneys involved, some of whom have been through difficulties themselves. I understand that lawyers are not the ones most, they're not as bad as at least one of the other professions in terms of a couple of these issues, but they're near the top of the list. And I suspect part of it comes from the intensely competitive part of it, and another is that law is not an exact science. There is not necessarily one perfect answer to each human problem that contains legal aspects. Note how I said that. Did I say legal problem, or did I say something a little more full and complete? This is actually an example. If the lawyer you worked for was hired to represent another lawyer, and there are legal cases that are brought to the state Supreme Court of the director of professional responsibility goes against an attorney, and the attorney tries to get the Supreme Court to rule in the favor of the attorney. The director is normally always been an attorney himself or herself, but the board that he reports to directly, he also reports to the Supreme Court, but the board of professional responsibility includes lawyers and non-lawyers. So it's kind of a misstatement to say lawyers are only regulated by other lawyers, and I don't think the Supreme Court, with their role, they have a much different role than practicing lawyers, even though they all were practicing lawyers at some time. So the individual lawyers, you might be surprised, but lots of lawyers hire a lawyer to represent them. So the director of professional responsibility goes against the individual lawyer. But even that case, which is clearly a legal case against the lawyer, has human non-legal aspects. Questions or problems with that? I hinted at a couple of the problems, didn't I? That are likely. Depression is a major one. Alcoholism is another major one, comes up over and over. Neither of those is an excuse, because if a person has those problems and it's likely to affect their ability to work with clients, it doesn't make what they do or fail to do excusable. The position of the law is that that person has to drop the practice of law during a period of time in which they get treatment, and then if they do that and don't do harm to clients, of course, they can come back. They're much harsher if they have to force the person into suspension. Can you see the difference? I mean, if somebody says, well, I choose to walk away for a period of time, but I have no clients, and then I'd like to pay for my license again later. Do you see how they would be justified in being favorable? Or somebody that quickly remediates their problems and turns their work over to other lawyers before it gets super serious. Yeah, but there's a human pattern that instead of somebody realizing their problem in the early part of the problem, they do this. They shift blame and overreact to criticism. And then it keeps going. Keeps getting worse. Overall quality goes down, and maybe others make up for it. Productivity goes down, and maybe the person just makes a little less money. But then all of a sudden, they're missing deadlines and calling up other lawyers, getting excuses. As I pointed out, the old buddy system usually doesn't work anymore, if it ever did. Miss a deadline, and the other lawyers are more likely to swoop down on it and take advantage of it and say, well, it may not be justice, but your client can get justice through the malpractice system. We won, you lost. Do you see where I'm coming from in a hyper-competitive system? Blow a deadline, and then you call up the other lawyer, and they're liable to say, well, tough luck, tell it to the judge. Of course, if a person was in a car accident and was on death's door in the hospital and something like that, maybe the judge will give them a break. But in some cases, the judge can't even give them a break. If it was a strict statute of limitations, the judge cannot extend that. It's just legislature comes up with statutes, and that's it. And Tara Nelson came up with better to cooperate versus resisting. Yes, at any stage. The same lawyer who advises other people to cooperate, sometimes if they end up with similar problems to clients, human problems that lead to legal problems, then it gets bad. Lawyers are sometimes, what do you say? Sometimes able to sort of, what do they call it, a functional, you call it a functional alcoholic, or able most of the time to sort of sober up long enough to get a bunch of work done. I don't know. So this is interesting. This is sort of a downward trend too. I think most of my students, because you're all adults, you've all been at different types of jobs. You've been around with in the rest of the world enough, even if you've never been in the legal world. I think you recognize what we're talking about here. Is anyone sort of flummoxed and bewildered by this? Most of us knew somebody like this even before we got involved in the legal world. Questions, problems? And of course, a lot of this is just from the lessons. So find it again in the lessons, and then of course, differently organized or organized by the person who created the course, okay? Who has similar experiences to mine, but different also. Okay. We talk about malpractice versus, well, if the person hurt clients, it's very serious, up to and including expulsion from the bar. I can't answer that, Kelly. I don't know. I would suspect less often from public defenders than others. But we have had really good public defenders in my area. They tend to become very good at at criminal and certain other public defense areas of the law. They tend to become very good at that, and their caseloads are often so large, though, that they do get an ability to delay a case sometimes when they need to, if that makes sense. If you've got a briefcase for a normal attorney, they're small, neat briefcases. If you look for a public defender briefcase, they're big because they get a lot of cases. But they tend to not. I don't know that they do much ethical bad stuff at the public defender level, you know, because for one thing, they're most of the areas they're now under salary positions rather than worrying about where their next meal is coming from or their next dollar that they need to pay the employees. So public defense is, and of course, some areas of the country, public defense is very undercompensated. I suppose they'd argue here that it's undercompensated in our state too, but it's not all that bad. I mean, it has attracted a lot of very fine attorneys, but you see the difference now. Can you see, though, where an ethical violation is often also malpractice? So if a person violates the diligence standards, that's also malpractice. But it may not work as malpractice because maybe there's no damages, okay? So I'm going to type that out even though I did say it out loud. So diligence actually is care. So that sort of muddies the waters, but in a way it doesn't, because if there are no ascertainable damages, then person just gets another lawyer. Do you see where I'm coming from? Let's say somebody wasn't diligent, then the person gets another lawyer and completes the case, and it's fine. The first lawyer may have violated the ethical standards, but really didn't commit malpractice that would lose. Okay? It wouldn't lose in court because the person has no damages. And the creator of the course makes this point. An ethical violation could be malpractice, but not always. This, I've never seen this, but there is a case. So I'm glad that I saw this, because otherwise I would have said, well, it's got to be some kind of a negligence, but not that kind. But after all, this legal case is an official case, so therefore it's right, isn't it? Another state may call it something else rather than legal malpractice, but it's going to amount to the same thing. A paralegal could be sued for negligence if there's no attorney supervising. So the upshot of that is, if you don't know if somebody is a licensed lawyer, find out. Actively working with you. Questions about that? Either of those cases. Paralegal competence. This was one of the objectives. It's very hard to learn this except in school. So work with me, work with our librarian. The 20-minute Dennis Johnson appointment. I really, really urge you to do that. And with tutors. Be able to properly research issues. Right. What if the lawyer didn't tell you the deadline? Would you be able to look up the deadline? Some of my students would be able to say yes, because I can find it in court rules, and others would say no. And of course, my position is always, instead of being totally lost and just saying you're confused, try to find some choices and offer the lawyer choices. So you say, instead of saying I have no idea what the deadline is, say, or this one, I can't find it. Find something. Yes. I called the courthouse And all they told me was, so do your due diligence, make your notes, bring it to the lawyer, make sure that the lawyer answers your question. But in some of these involve phone calling and some involve research, but you might call it all research. So you're looking in statute, you're trying to apply it, you're trying to find rules, you're trying to call people, and you're setting out questions. You aren't just sitting there stewing about it, okay? Can you guys see the whiteboard with the line? Number one, get help. Number two, don't be embarrassed about putting your preliminary thoughts and where you're stuck down on a page. Put it on a page, put it on a page. Yep, ask another paralegal. And I will try to come up with actually I did come up with a memory tool on that too. Right. But some of you are going to end up working with one lawyer who is gone. And if the lawyer is gone for more than one day or so on, hopefully the lawyer has got a backup. You know, when I went for a week away from vacation, I talked to Mr. E, and I said, anything that seems like a deadline, bring it across the street. And we walked over there and talked to the other lawyers and said, well, if something comes in that is new or that needs to be completed while I'm gone, would you guys do it? Yes, we'll do it. And so somebody came in for just one more lease that we had done leases for before. And instead of just typing up the one we had done before and then trying to telephone me at the resort and all, Mr. E walked the person across the street and set them up with the attorney. And the client calls me later, well, I could have just had your paralegal do it. Now, why did we forfeit the money and just let somebody else do it while I was gone? Why? There are different resources for finding certain issues, but I don't know about Facebook. But this is a good example of where we decided not to be hyper competitive. And I told the client when I got back, client says, I apologize for going along with that. I said, no, that's exactly what I wanted you to do. If you'd have lost your rental deal or whatever, rental lease, can't remember. But if you'd have lost even one day, then I would have felt bad about it. I said, I'd much rather you pay another lawyer, get it done when you wanted it done, rather than lose anything by the fact of me not being available. Okay? So do not, if there should be a backup, in other words, if there's no other lawyer in the office that can do it. And this is the duty to report. Clearly demonstrates, and of course, maybe it doesn't clearly demonstrate, so there is fraud, deceit, dishonesty, or misrepresentation. So the NFPA code does say that you should report if it's one of these serious things, but otherwise, its proper authority is kind of ambiguous, but maybe it isn't. Of course, that's the other thing. Non-confidential, that's a good question. Non-confidential. So there's a lot of thinking to do on this duty to report. You have to think of different examples to make it work. Law office work may be a major strain, but don't let it defeat you. And this is just my own, completely my own thing here. Most of the rest of the posts or a lot of the rest of the ones that we've done so far were pre-done. But I hope that you take some of this to heart and don't get into this career and then worry yourself sick. Too much to do is not your fault. Who had to accept cases? Who decided to accept 75 cases when maybe 45 would have been a better idea? The attorney. So is it your fault? No, not your fault. So don't pretend like it is. Don't let it get to your emotions that it is. If the lawyer took on too many cases or the lawyer's disabled, it's not your fault. There are a number of cases to process at one time, and that's normal. Too many cases, though, unfortunately, is average but not really correct. While the attorney is focused on one case, the paralegal may need to do a workup on a different case. Most attorneys have not taken a course in management of supervision. Most have not been managers before being busy lawyers. So organize, communicate, and go home on time. And I will help you learn those tips. In other words, if you've organized, you've communicated, then I want you to leave it go. And of course, if you work from home, of course, it's a problem because but you need to, if you have especially if you have a dedicated computer that you do, laptop that you only do law office work on, turn that pup off. It has an off button. Okay? Turn it off. Quit. Quit for the day, quit for the weekend. It's not your job to worry about it all night or all weekend. Organize, communicate, go home on time. Show. So I'm doing one of my acronyms. Say, I want you to learn this, and I will quiz you on it. A no lose quiz. In other words, you don't lose points by taking the quiz. Save, help, organize, write. SHOW. Okay. Save, help, organize, write. If there's mistakes and omissions, keep track of them. And this is basically, I'm talking about the idea that there is a ethical situation going on, or there might be. So what do you do after you save? Well, be helpful. Tara is bringing up something. NKB is bringing up something. Getting emotionally involved is a part of this because you end up wanting to win as well. And I don't want you to be in that middle manager position where you're worrying about things that you have no control over. What you have control over is just what you do. You cannot govern the final result, and frequently, of course, the lawyer cannot, which is partly why lawyers get all worked up. A lawyer has to say, in all truthfulness, if not to the client, to themselves, is, I don't know what the judge is going to do. Or if they handle most of the cases that don't involve going in front of the judge, I am not sure what the other side is going to do when they negotiate for their side. There's uncertainty, and the lawyer needs to be able to deal with it. If they can't deal with it, they're in difficulty. But so compile things, save, then help. Get help from others. Do not be embarrassed to seek help. Organize, do calendaring, reminders, and notes. In other words, there's nothing wrong with you doing some notes for yourself. Different alternatives, problems you see, make notes on it. You may not need to use those notes, but it's so much better to just keep notes. Let's say it's a Friday at 3 and you are just stewing about stuff that is not being done right. Instead of sitting there stewing, and then wondering whether you'll remember it on Monday when the lawyer gets back. The lawyer's gone. Lawyer left early. Make notes on it. Then you do not have to think about it all weekend to try to remember it. It's in your notes, okay? Seek help. So save, help, organize, do calendaring, and then write, communication. Normally it's to the attorney involved, but also to others. Then go home on time. You're not supposed to solve all the troubles. Document them, put them on the desk or computer of the supervising attorney. Get it saved. Do a memo. And you have to use your own best judgment, but save, help, organize, write. What does that show? A, B, C, or D? I just taught it to you 2 minutes ago. Okay, you got it. Save, help, organize, write. A misguided use in our story for this week, there's a misguided use of what I call friendship ethics. Two people come in for a divorce, and they not only want the lawyer to represent both of them, which is it's a conflict, and I don't think it's even really waivable. In my state, it's not even waivable. But even if in your state it is waivable, it's not very wise to try to represent two parties in a dissolution of marriage or divorce. And then the lawyer takes off on a sudden impromptu Las Vegas vacation, leaves it in the paralegal's hands to sort of be the lawyer. And I would say this is a total mess. I'm not giving away the whole story of what to do, but I am just being very open and upfront. This is a total mess. There's multiple ethical issues here. You are not expected to totally solve them. What you're expected to do is to cope with them with ethical rules from your state and case decisions. Okay? So use state professional responsibility rules and cases first. Fill in with NFPA, other secondary sources later, okay? Any questions about that? If you've really been doing actual research in Lexis, in-depth research, you will see the scope and depth of the troubles in this week's story problem, this week's written assignment. There are a lot of hints in the lesson, such about when a paralegal should report. So there will be some things that are not covered in primary sources. There's no real mystery in the fact that you were given the NFPA comments, okay? But that doesn't mean you should start with that, because that's the easy part. The hard part is to cope with the professional rules in your state and the case decisions, okay? But if you go into no depth to speak of, get started. If you go into too much depth and you're constantly second-guessing yourself, stop it. And I know there's some in both categories. There's some that are once over lightly and just taking a few things from the lessons and then going with it. And then there's some that are going probably stressing out too much about it. Set a timer for yourself. If you're overdoing it, spend 5 minutes proofreading and turn it in. Do 2 alternative answers to something rather than going into circles mentally. When in doubt, type more. It's actually faster. You can get a lot of typing done in a short time. I'm not saying you shouldn't overthink either. Go ahead and overthink, but put both sides of, put that thinking down on the page and then stop worrying about it. Any questions about that method? So you may type more. And I'm not contradicting the other teachers that insist on brevity. Brevity is wonderful. It's just not what I personally teach. Okay. Now, when you're working in a law office context, you're probably going to be forced into brevity by the nature of the rush work. But in school, I want you to try both. And eventually, you're going to split off some of the extra explanation stuff into your notes. And then when the lawyer says, I don't like any of this, what is all this? You can say, well, I made some notes. I can redo it based on the other alternative. Oh, I didn't realize you were making notes. Well, I have to make notes because I know you wanted it brief, but if I come up with something that you really don't like, maybe some of my notes fill it in, okay? Any questions about how I think this applies or how it works? So, in other words, I'm letting you do more and just put it into the assignment, but I'm not suggesting that you do precisely this in a similar situation in a law office. In a law office, you're probably going to put part of it in your notes and not turn it in. As far as I'm concerned, just turn it all in, okay? Your other instructors are probably going to want you to pare it down to the essentials. And they are not wrong. They are complementing what I teach. They're teaching you a different skill. You need both. You need both skills. Which of these skills does Kirk Olson teach? Expansion of thinking in law office writing, editing down content to only the essentials, giving a main answer followed by other answers, or A and C. Which is the best answer? Okay, I see some D's. I see some D's. Okay. Obviously, it's risky for me, but I have never, nobody has ever taken it and run with it to the extent where I had to really tell somebody, oh, I didn't want a 100-page paper. Nobody has done that. If you write a huge paper, I probably am going to hope that the essentials and the second option are near the top, because no, I'm probably not going to read 100 pages. But if you read, if you exceed the page numbers, though, that's okay. But put your top choices of the way you think that you would answer in a law office, put your very top choice up on top, and your additional thoughts that are most likely the ones that you would present to an attorney. If the first ones were not acceptable, put those below, and then put all of the additional items below that. So it's a law office standard. So the things that you would have in your notes, you're rethinking and rethinking, that would go at the bottom. Okay. Are drinking and heavily in gambling your supervising attorney's main recreations? Are cases being neglected? These are questions that lead to ethical problems. You don't necessarily have to use a confrontational style. with the attorney, just simply asking the attorney to do a case review in the morning. You could offer to come early. I'd rather have you offer to come early than to stay after. Staying after can be a big problem. But oftentimes you could come a half hour early and just do a case review with the attorney, either with physical files or with electronic files, and try to check off the ones that are fine. Well, we have a whole bunch of them that actually are fine, but these 3 files are really problems. You don't know what to do, and the attorney is not giving any directions, and it looks to you like their deadlines are going to create a problem. That's probably what I would do if I were in your shoes as a paralegal. I would try to pare it down to those things which are a problem. If they are a problem, then you can, without being confrontive, you could just say, well, what should we do about these? It may be, Kelly, if it's, but I would get outside counsel before I did that, Kelly. But I would tend to, I think in most instances, you're going to be able to convince the attorney to do something, either to complete the case or to get another lawyer involved. If you can't do that, you may have to actually just walk away. If it's that bad. But you may have to call the Professional Responsibility Board or Lawyers Concerned for Lawyers. Yeah, but if you approached a sound practitioner and basically the good practitioner said, well, you're pretty hard on your former lawyer, the lawyer would be looking up and seeing that the Supreme Court disciplined the other lawyer for something. It's not going to go against you that you tried to solve the problem. Being too much of a problem solver is not going to hurt you in the eyes of the lawyers that are doing their job, in my opinion. Which is your choice, A, B, or C here? This is kind of easy, I suppose. Wasn't intended to be super easy. You can't ignore it. Unfortunately, this is the answer that a lot of people have. You can't do that as a paralegal. People are not paying you hundreds of thousands of dollars, millions of dollars to fix the world. Don't do that. Okay? Organize, write, leave it on someone else's desk, even if it's a professional board's desk. You're asked to review a professional responsibility issue. And I'm not saying it's about your lawyer. It could be about anybody. A, B, or C. I know we're out of time here, but it's big stuff. The last quiz, I'll put it on an announcement if I can, okay? Anyway, the answer to this is, sorry we ran out of time to do more on that, but we don't want to ignore methods and knowledge. We don't want to just quick check the rules without cross-referencing. This one is attractive to me, but it's wrong. Okay? Don't use what you recall from me. Do your own research and critical thinking when you run into a legal issue. Show and tell. Show and tell. And I'll show you the meaning of show and tell in just a bit. I am sure you already guessed what show and tell means this week, right? It's SHOW that I talked about before, and then of course tell. Tell the attorney you work for. If that doesn't work, you have to go up the chain of authority, really, if it's that bad. Tell what kinds of, and I'm not answering the question because I don't have some kind of a wonderful answer. The NFPA doesn't either. They're just giving you guidelines, not final answers, okay? Again, which does SHOW stand for? Save, help, organize, right. And help means get help, of course. And we won't cover this one. I guess we already did. Critical thinking at Rasmussen College is a fair way to explain somebody's faults. No. Reviewing the thinking of sources and instructors, that sounds good, but it's not the best answer. That's an arguable answer, but it's really critically important individual thinking. That's what I want you to do. Thanks for attending. I appreciate it very much. And I will stop the recording.